Mackenzie Shirilla, a case of a wrongful conviction. Part 5. In this part we will discuss the following. Post-crash hospitalization. Lack of remorse theory. Driver's license renewal. Media sensation. Police investigation, concerns and evaluation. Prosecution evaluation. And conclusion. Post-crash hospitalization. Erratic behavior and medical explanation for said behavior. Upon arrival at the hospital, Mackenzie was examined by Dr. Sang, a trauma surgeon. As Mackenzie was examined, medical staff connected her to an electrocardiogram, ECG, also called an EKG, to obtain constant readings of heart rhythm and other vital signs. Dr. Sang testified that Mackenzie didn't display any signs of stroke or seizure activity. However, due to the extended delay from the time of the crash to the time of treatment by Dr. Sang, it is possible that signs of seizure had subsided. It should be noted that the only device that can measure a seizure is an electroencephalogram, also known as an EEG. According to the Cleveland Clinic, an electroencephalogram is as follows.
What is an EEG? An EEG, electroencephalogram, is a test that measures your brain activity. Healthcare providers order EEGs to diagnose conditions that affect your brain. An EEG test measures the naturally occurring electrical activity arising from your brain. During an EEG, a technician places small metal discs, electrodes, on your scalp. The electrodes attach to a machine that monitors the electrical signals that your brain cells, neurons, make to communicate with each other. Monitoring that communication shows how well the different areas of your brain are working. Why is an EEG done? Typically, healthcare providers order EEGs if you have seizures or if they think that you may have epilepsy. Your provider may order an EEG if you have symptoms that could be a result of an undiagnosed epileptic condition.
According to both detective notes and the appeal response by APA Troop indicate only an EKG was used and Mackenzie's case was never referred to a board-certified neurologist, who would have more advanced training in neurological conditions such as POTS and tonic-clonic seizures. However, according to the Cleveland Clinic, EEGs are not effective in providing a historical record of previous seizure activity. Unlike other medical conditions such as heart attacks or strokes, which leave physical evidence, seizures do not because of the nature of the condition, which is electrical activity in the brain. In fact, if Mackenzie had a seizure in court during the trial, in front of many witnesses, by the time she was seen by a doctor at the emergency room, it's possible that no signs of seizure would be present. According to detective notes, on August 1, 2022, at 9:05 a.m. Detective Hazu and Glover arrived to see Mackenzie. She appeared to be awake and alert. Her neck was in a brace, and her right arm and both legs were bandaged. The conversation was not recorded due to privacy concerns given the sensitive nature of the location. According to Mackenzie's mother, Natalie Shirilla, Stephen Shirilla, Natalie's husband and Mackenzie's father told both Mackenzie and Natalie that they should not speak to police without a lawyer present, even though Mackenzie was not considered under arrest or in custody at that time. Detectives provided business cards to Natalie. Natalie did provide information that the Russo family had already been in contact, and she expressed extreme sadness for the loss of Dominic and the loss of Davion. Mackenzie did not say anything and only responded by crying. During the meeting, Natalie asked about Mackenzie's cell phone and if it could be released. The detective stated that it was evidence and could possibly contain information that would help put together information leading up to the crash. Prior to leaving, detectives indicated that they would like to sit down and interview Mackenzie as soon as she was discharged and with an attorney present if they would like. During a follow-up visit at the hospital a few days later, Detective Hazu was speaking to the Shirilla family and in the course of that conversation, Mackenzie turned to Detective Hazu and said, "Take my whole license away for like 10 years or something like that." This response may not be a response due to perceived wrongdoing as speculated by police and the prosecution, but it could have indicated that Mackenzie may have recognized that she may have had a yet undiagnosed medical condition that would make it hazardous for her to operate a motor vehicle safely. On August 6, 2022, at approximately 6:50 p.m., hospital security responded to Mackenzie's room where she was being treated because she was being combative. Officers took no action and only stood by. It should be noted that combative in a patient care setting is a loose term for an uncooperative patient. Causes for patients can occur due to fear, or they are in pain. Sometimes patients are combative due to injuries, such as head trauma including concussions, like the one that Mackenzie sustained in the crash. According to detective notes, on August 6, 2022, at approximately 9:30 p.m. Mackenzie was crying, distraught, and even threatening to leave AMA or against medical advice to attend Dominic's funeral. It should be noted that Mackenzie's injuries were so severe, that leaving was next to impossible. Mackenzie couldn't even walk, so how would she leave on her own? Mackenzie's parents and hospital staff calmed her down to the point she agreed not to leave the hospital against medical advice and agreed to attend the funeral virtually, via face-to-face video technology, example, Skype. According to police interview with Paul Burlinghouse, when he visited Mackenzie in the hospital, he stated that she was, in his words, devastated at the loss of Dominic. It should be noted that after Mackenzie had been medically cleared and discharged from the hospital, she was not immediately arrested and placed into custody. It should be noted that Mackenzie received several severe and life-threatening injuries in the crash. Among the injuries she sustained include fractured C1 vertebra, fractured 8th, 9th, and 10th ribs on her right side, broken right humerus, broken right femur, severe laceration to left knee, multiple lacerations to her liver, slight tear to one of her carotid arteries in her neck. Additionally, when Mackenzie was being stabilized in the ambulance, she had a low blood oxygen level of 82%, which is considered a life-threatening condition. Lack of remorse theory. The prosecution presented evidence of Mackenzie's apparent lack of remorse, which is completely unfounded and not supported by any credible form of mental health professionals and is open to interpretation. In fact, it could be considered a form of bias. Regarding remorse, it is a double-edged sword for Mackenzie. In either way, it heavily favors the prosecution just by making the statements. If Mackenzie demonstrates remorse, it could be interpreted as she is guilty. If Mackenzie does not demonstrate remorse, it could be interpreted as she is cold and calculating, and therefore she is guilty. However, if this is an accident, as Mackenzie and her supporters believe, not demonstrating remorse could also be interpreted as it was an unfortunate accident and she is innocent. With that said, a more appropriate statement would be, did or does Mackenzie demonstrate empathy and sadness to the loss of Dominic and Davion? The answer to that question is yes, she did and continues to do so. Looking at how Mackenzie demonstrated empathy and sadness at the loss of Dominic and Davion can be viewed on her social media postings. One of the first examples of Mackenzie displaying empathy is by her posting on her own Facebook page 2 links to Dominic's and Davion's GoFundMe pages asking her friends and followers to donate to help the families pay for funeral expenses. If Mackenzie was narcissistic as claimed by others online, she wouldn't have mentioned their names. She would have posted her own GoFundMe page asking for financial assistance. Looking at these postings on Mackenzie's social media, it shows that she deeply misses Dominic. Again, if Mackenzie truly hated Dominic or intentionally killed him as the prosecution wants us to believe, Mackenzie would have never mentioned his name again. Instead, what do we see? We see that she mentions things like his birthday, the good time she had at the carnivals, referring to Dominic by a nickname, Nug. And she believed his spirit was with her in the form of lovely sunsets. These are postings of a devastated teenager trying to cope with the reality of a severe loss. Additional, alleged, proof of lack of remorse came up in the forms of people who obviously disliked Mackenzie as the investigation was ongoing. These people reported to the police communication concerning a potential modeling career. Mackenzie, Natalie, Mackenzie's mother, and a modeling agency were in communication.
@Mackenzie Shirilla. Can we use this post on our website and emails? We'll make sure you're credited. Reply to this comment with #community if you do.
Natalie Shirilla replied.
Thank you for this amazing opportunity. Hello, this is her mother. She would love if you would use that. She's actually been trying to contact you guys for email. It was a tragic accident, and she did not purposely mean put an end to any of her close friends' life. This is just as painful as it is for her as it is for everyone else, or maybe even a little bit more painful.
Mackenzie said.
Thank you for the comment. I would love to work with you guys. I've been emailing you guys a lot. Such a great opportunity, thank you.
Some were outraged by this and forwarded this information to the police. However, the information contained in the message, it appears that this was a continuation of an existing conversation with the agency that started well before the crash. We must remember that this modeling agency reaching out to Mackenzie had no idea what happened. We must also remember that this was a very, very dark time for Mackenzie. When presented with nothing but bad news, it's very easy to slip into a very depressive state. This communication from a modeling agency she had been trying to talk to, might have been enough to raise her spirits. While communication after the crash may upset people, the question must be asked. If you could have told Mackenzie what to do, how would you have preferred her to act? Additional, alleged, proof of lack of remorse, came up when Mackenzie attended a concert. Pictures of Mackenzie attending the Moon Man's Landing concert on September 17, 2022, 49 days after the crash. A concert that was attended by over 18,000 people, according to estimates by news reports. It is apparent that Mackenzie did not drive there on her own. She is seen confined to a wheelchair. Another point to consider. Who was at the concert and took such a keen interest in a nondescript teenager in a wheelchair? Was this a private detective? Was this a person with a vested interest in trying to portray Mackenzie in a bad light? Could that be considered stalking? Again, the question must be asked. For those so upset, how should have Mackenzie behaved in the days, weeks, months after the crash? It should be noted that Mackenzie's facial expressions in the photos do not indicate that she is having a good time. From her facial and body language it appears that she is sad, depressed, in pain from her injuries, and bored. In fact, according to her friends, most of her time was spent crying and wishing Dominic was with her. According to her friends and family, this was one of the first times after the crash that Mackenzie was out in public for social reasons. Additionally, because of Mackenzie's injuries, she was unable to drive to the concert and was seen being pushed around by an unidentified person. Finally, Mackenzie at no time was seen dancing or partying. Only present at the concert and listening to music. As Mackenzie continued to heal, she began adjusting to a life without Dominic. Additional information has been made public, including videos that Mackenzie made and had posted to her social media pages. Specifically, a video that says, "I'm just a girl you can die for," and a video that says, "I'm just a girl who can take a lot of drugs and not die." However, what was erroneously left out, were the dates and times these two videos were originally posted. The reason why the dates and times were not published is because they were posted at least a year prior to and are completely irrelevant to the crash. On October 30, 2022, Mackenzie and her friend posted on social media a video of them dancing to a song called "Drank and Zaza." APA Tim Troop made a grandiose blanket statement saying that these actions show a blatant lack of remorse. However, if Mr. Troop had taken the time necessary to perform due diligence, he would have discovered a few things about that video. The music in the background is by an artist known as Odimeboy. When a check on the website www.qobuz.com, which is a digital music store and streaming service, Odimeboy is the musical artist's name of Dominic Anthony Russo, Mackenzie's deceased boyfriend. If you will notice, Mackenzie once again refers to Dominic as Nug. "Drank and Zaza" was a song that Dominic wrote, and this dancing that so many found offensive, was in fact Mackenzie's way of trying to remember the good times with Dominic by dancing to his songs. Finally, on the day of her arrest, Mackenzie was wearing a shirt that says, "Oh Dime Boy," her deceased boyfriend's artist name. By dancing to his music, by wearing a shirt with his name on it, it indicates that Mackenzie was still upset by Dominic's passing. The prosecution says this whole thing was intentional because of a toxic relationship. For someone who is supposed to have hated her boyfriend, it seems very odd to be constantly reminded of him and his passing. Wearing his shirts. Wearing a memorial bracelet with Dominic and Davion's names on it. Dancing to the music Dominic made and referring to Dominic as Nub. While others disagree with her post-crash actions, it is not for us to dictate to her on how she is supposed to act and behave at the loss of someone she cared about. Driver's license renewal. Regarding Mackenzie's application for a new driver's license. According to the Bureau of Motor Vehicles, it is stated that Mackenzie answered no to the following questions on Form BMV 2002. Suffered from a condition that resulted in episodic consciousness or loss of muscular control. Suffered a physical or mental condition that prevented her from exercising reasonable and ordinary control of a motor vehicle. Was chemically dependent on alcohol or a drug of abuse or currently using alcohol or drug or abuse. However, on numerous Bureau of Motor Vehicles forms, example, BMV 5745, it has a warning and catch-all defense. Warning. It is a criminal offense to give false information on this application. Under penalty of law, I affirm that the above information is true to the best of my knowledge and belief. Now, as stated, because the form contained the language or something similar, there is a reasonable response to the answering of no. Looking at the language, it is reasonable to think that Mackenzie believed she was answering truthfully. This is especially important because if Mackenzie hadn't been officially diagnosed with a debilitating condition by a board-certified doctor at the time of answering these questions, she was answering truthfully. Which is why it has the language, I affirm that the above information is true to the best of my knowledge and belief. The use of the term, to the best of my knowledge and belief, recognizes it is impossible for any person to legitimately provide absolute assurances or guarantees. Applicants can only make assertions on what they know or have knowledge of, not to what they don't know. This terminology is intended to provide reasonable exceptions, such as an undiagnosed medical condition that an applicant may not be aware of. Put it this way. Say you sign a document that says you do not have cancer. The form says, I affirm that the above information is true to the best of my knowledge and belief. 5 weeks later you go into your doctor's office for what you believe is a cold that won't go away. They do a chest x-ray and see a mass in your right lung. A biopsy is performed and the results come back as cancer. Earlier you signed paperwork that you didn't have cancer, but now a doctor has told you that you have cancer. So, did you lie when you signed, or did you simply sign because at the time, the answer was no, and you answered in accordance, to the best of my knowledge and belief? Media sensation. In true media fashion that follows the typical, if it bleeds, it leads, mentality, media began circling around the case almost immediately. On more than one occasion, news reports showed the battered remains of Mackenzie's vehicle and the amount of damage. Many people questioned how did Mackenzie survive, but Dominic and Davion didn't. Let's keep in mind the car was partially dismantled by the fire department in their rescue and recovery efforts. However, the condition of the vehicle itself did not look so horrible in comparison to the view shown on the 6 o'clock news. In fact, with the exception of the front engine compartment, the car was mostly intact. The crumple zones designed in the vehicle did its job, and passenger compartment, where Mackenzie, Dominic, and Davion were located in, was intact. Again, had Dominic and Davion been wearing their seatbelts, their chances of survival would have greatly increased. Police investigation. Concerns and evaluation of the investigation. With this case, there are numerous issues and some major causes for concern. The purpose of any law enforcement investigation is to determine what happened, regardless of the investigating officer's personal feelings. Any potential arrests or exonerations are secondary. However, it is apparent through the detective's notes that they were focused on not only arresting Mackenzie but ensuring that she was convicted. This led to many missed opportunities to properly explain the crash, such as a medical emergency. The lead detective in this case was Detective Zaki Hazu, who was promoted to detective in June of 2022 and had less than 60 days in the role at the time of the crash. Due to the seriousness of the case, the investigation should have been handled by a more experienced detective who had a less motive to prove himself as a good investigator. Another issue of concern is from what occurred in the ambulance after Mackenzie had been freed from the wreckage of the vehicle. First is an apparent Health Insurance Privacy Protection Act violation. This is mentioned because in the ambulance, the police officer in the ambulance is only observing with his body camera actively recording. He is not actively providing patient care. This appears to be a violation of HIPAA because anything of a personal sensitive nature may be said in front of a person who is not authorized to hear such information. United States Health and Human Services view the entire ambulance as a covered entities, which is required to maintain compliance with both the HIPAA privacy rule and HIPAA security rule. Because the body camera was recording, it puts Mackenzie's personal patient information at risk to those who may view that information in the future. Another cause for concern is the fire personnel conducting an invasive search on Mackenzie, which resulted in mushrooms and digital scale being found. While the fire department personnel are not law enforcement, and it can be argued that medical personnel must remove items on a person to conduct potentially life-saving medical care such as CPR or using a defibrillator, or looking for information such as a medical alert bracelet, or prescribed medication such as insulin, it creates a legal gray area. However, in Mackenzie's case, because the law enforcement officer is in the back of the ambulance, it can be argued that medical personnel were under the direction, directly or indirectly, of said officer. In that case, the Terry-Frisk rules applies. This sets a dangerous precedent that if an officer feels a person is a suspect of a crime, but is unable to justify a search, then, in theory, that officer could request an ambulance to check the patient, thus circumventing the Terry-Frisk requirement. Because Mackenzie was in and out of consciousness and has no memory of what happened, she represented no immediate danger, so a Terry-Frisk is unwarranted. Since Mackenzie was not considered under arrest or in custody during her time in the ambulance or on the medical helicopter, the search cannot be considered as a valid search incident to an arrest. Furthermore, Mackenzie was not arrested while in the hospital, nor was she arrested when she was discharged from the hospital. Therefore, this search conducted by non-law enforcement personnel should have been considered invalid and inadmissible under the fruit of the poisonous tree doctrine. A person's constitutional rights do not simply disappear because the person is unconscious or in a mind-altered state such as the one Mackenzie was in while in the back of the ambulance. After the crash, detectives were notified on 2 separate occasions of Mackenzie's previous POTS diagnosis, yet performed zero research into the subject. Based upon the detectives' notes, the detectives did not consult with any board-certified neurologist regarding Mackenzie's POTS diagnosis. Police could have obtained a court order so as to conduct an interview with Mackenzie's neurologist. It appears that this avenue of the investigation was never explored. Additionally, it does not appear that detectives researched this condition or any related conditions on publicly available medical documentation sites such as the Cleveland Clinic, the Mayo Clinic, Johns Hopkins, or the National Institute of Health. Another concern is noted on page number 46 of the detective's notes and his interview with Christine Russo. The concern that is noted is her refusal to give consent to the police in order to search her son's cell phone under attorney-client privilege.
Next, I asked Russo for consent to search Dominic's cell phone, which at the time was in police custody. Russo denied consent to search the cell phone, citing confidential communication attorney-client privilege communication with Dominic. I explained to Russo that during the interview with Blair Wallace, he revealed that Dominic had tried to call him via FaceTime around 0300 hours, and that Dominic had texted "I love you" to at least one friend and family members. Russo volunteered to obtain the call log and text message log from Dominic's cell phone from the cell phone's online account My Verizon. Russo added that Dominic was more of a caller, that he was a texter. Russo explained her desire to obtain Dominic's phone citing his online investments, business accounts, and cryptocurrency accounts which are only accessible via the respective applications installed on his cell phone. According to Russo, Dominic was in the music recording business. I told Russo that I will convey her request to obtain Dominic's phone to APA Troop to decide.
This is extremely disturbing and further hampers a proper police investigation. The phone could have contained other potential information. Example, it appeared in the video captured at Pearl Road and Progress Drive that an electronic device, possibly Dominic's cell phone, was on and visible. What was displayed on that device is important to know. Example, perhaps it was a map or directions to Mark's residence on Westwood Drive. Why did the police not simply state to Christine Russo and provide the exact same reasoning they provided to Natalie Shirilla? That reasoning was, they believed it contained digital evidence that could help piece together the events leading up to the crash and that the police would seek judicial approval to collect the necessary data. Eventually Christine Russo did allow retrieval of information from Dominic's cell phone, but not in the same manner as information was retrieved from Mackenzie and Davion's cell phones. For data from Dominic's phone, the phone was handled differently. Specifically, the phone was going to be examined and data would be recovered from a third-party law enforcement agency that was otherwise uninvolved in the investigation, specifically the United States Drug Enforcement Agency, Cleveland District Office. Why was this done? Why was it so important that an uninvolved third-party federal law enforcement agency become involved? Was there trust issues and Christine Russo did not trust members of the Strongsville police? Or is it possible that there might have been incriminating evidence and violation of state law which federal law enforcement officers are prohibited from investigating and enforcing? Did the DEA who looked at the phone actually recover all relevant data necessary to the case, or were things missed? We may never know. Another concern was the interview with the key eyewitness, Christopher Martin, who stated in audio recording that he was friends of the Russos because Christine Russo was his attorney on some unrelated legal issues. Mr. Martin was interviewed on November 1, 2022 about the altercation on Interstate 71 which he incorrectly stated was 1 week before the fatal crash. The fatal crash was on July 31, 2022. The altercation on I-71 was on July 17, 2022 which was 2 weeks earlier. 1 week before the fatal crash would have been July 24, 2022. Because of the inconsistent dates, and previous legal issues, his statements are questionable at best and makes him an unreliable witness. Mr. Martin stated that he was with Christine Russo at her residence when Dominic called and asked to be picked up. Mr. Martin stated in his interview that when he was on the road, he told Dominic to tell Mackenzie to pull the vehicle over. However, this is in direct contradiction to what the text messages between Mackenzie and Christine indicate. The text messages from Mackenzie states, "If he, Dominic, doesn't get out of my car, I'm calling my dad, so please tell him to get out." And he's not getting out. Reasonably indicate that Mackenzie had already pulled over onto the shoulder prior to Mr. Martin's arrival. Finally, there is the interview with Angelo Russo, Dominic's brother. Angelo Russo came to the police station to speak to them about this case. His mother, Christine Russo, was in the interview with him. Normally this type of interview is not allowed and potential witnesses must be interviewed separately. However, Christine Russo is a defense attorney and it could be argued that she was providing legal representation for her son Angelo. However, because Christine Russo is a defense attorney, she had a direct conflict of interest in this case. Because of this conflict of interest, what is she? She seemed to wear different hats as the situation required it. Is she a parent of a crash victim? Is she a legal representative for her sons? Was she a witness? Because of her unique position, it appears that she purposefully exploited this opportunity and potentially manipulated the investigation. Only she was allowed to be present during another witness interview, Angelo's. Only she was allowed to be a witness, and when asked about Dominic's cell phone, she switched to lawyer mode and cited attorney-client privilege. She was the only one who insisted on extra steps to be taken regarding Dominic's cell phone and have a third-party law enforcement agency obtain the data. Why is that? Finally, at the crash scene, the way that patrol officers collected potential evidence was completely inappropriate and shows a complete breakdown of how to properly collect evidence. Strongsville Police Department body cameras recorded uniformed police officers grabbing Mackenzie's purse and other similar bags and stuffing items and debris. In a "grab it now and we'll bring it to the evidence room and figure it out later" attitude. This is a completely inappropriate way of handling potential evidence. No photographs of the item being recovered before handling. No crime scene inventory log being used. No proper containers of evidence/property being used. Along with no apparent crime scene personnel log being used. The exact opposite of how law enforcement officers are supposed to be trained according to U.S. Department of Justice Office of Justice Programs. This slide displays the requirements for evidence collection in accordance to the U.S. Department of Justice, Office of Justice Programs. Prosecution evaluation. From the detective notes along with briefs filed by both the prosecution and the defense, it appears the prosecution was fully committed in charging Mackenzie with anything they could. Because Mackenzie was 17 years old at the time of the crash, she had to be first charged as a juvenile, and thus her first appearance was in juvenile court. In that portion of this case, the juvenile court told prosecutors that they failed to provide probable cause to warrant aggravated murder charges, but stated they would bind the case over. After charging Mackenzie as an adult, the grand jury appears to have rubber-stamped the prosecution side. Including the aggravated murder charges, the juvenile court said no probable cause existed. However, in their haste to charge Mackenzie, they failed to follow the proper steps. According to Mackenzie's appeal brief filed by her attorney, it was brought up a critical step had been missed in prosecution's case. According to Ohio law, Section 313.19.
The cause of death and the manner and mode in which the death occurred, as delivered by the coroner and incorporated in the coroner's verdict and in the death certificate filed with the Division of Vital Statistics, shall be the legally accepted manner and mode in which such death occurred, and the legally accepted cause of death, unless the Court of Common Pleas of the county in which the death occurred, after a hearing, directs the coroner to change his decision as to such cause and manner and mode of death.
There are several reasons why this is an issue. First, the coroner ruled Dominic and Davion's deaths as accidental. Because it is difficult to charge someone with murder when the official cause of death is accidental, the official causes of death had to be changed. The prosecution contacted the coroner's office and requested a change. A change that the coroner granted by supplying an addendum. However, this is a direct violation of Ohio law, Section 313.19. The prosecutor never requested a hearing in order to change the official causes of death for Dominic and Davion as required by law, which means the original causes of death should be reinstated. Which means Mackenzie should be released, because how can one be in prison for murder when the official cause of death is listed as accidental? Additionally, in their response raised by Mackenzie's lawyer saying that the defense did not have the opportunity to question the personnel who performed the autopsies at trial, which is a violation of Mackenzie's Sixth Amendment, the prosecution stated, however, the state has never briefed a confrontation clause issue in this case because the issue was never raised in the trial court and was not raised by appellant in her merit brief. In consultation with trial attorneys, the prosecution inadvertently informed the appellate court that Mackenzie's lawyer at trial was ineffective and provided ineffective counsel, which is grounds for a retrial. Conclusion. In conclusion, the information contained in this presentation should provide proof that more than enough reasonable doubt exists in this case. To recap, there was the alleged threat Mackenzie supposedly made to crash the car. A threat that could not be confirmed by the police. No audio or video recording of the threat exists, only one person's word. 3 Google Maps from the start and end locations provided. One map shows the exact route that was driven the morning of the crash. How does this prove anything other than the ability to follow directions from a third-party web mapping platform? Mackenzie has pre-existing medical condition that is related to seizures, yet these were never explored or looked into. Yet information from the Cleveland Clinic, Mayo Clinic, Johns Hopkins, and the National Institute of Health say it's possible. A board-certified neurologist appears to have never been consulted in this case. The theory that this was a toxic relationship, but no calls were made to police requesting their assistance in domestic violence or abuse, or assault in which Mackenzie was the aggressor. Further, there were no court-issued protection orders to Mackenzie instructing her to stay away from Dominic, his residence, his family, his workplace, or any other locations. In fact, the only proof of any form of violence to injure someone was when Mackenzie contacted Christine Russo informing her that Dominic attempted to crash the car, not her. Lack of remorse theory is non-existent when compared to Mackenzie's social media posts expressing her remembrances of good times, her dancing to Dominic's music, wearing Dominic's, musical artist, name on a shirt. What it does show is Mackenzie was very empathetic and misses Dominic very much. According to the Kubler-Ross model of grief, everyone directly impacted by this crash began experiencing the 5 stages of grief. Those stages are denial, anger, bargaining, depression, acceptance. Anger is very evident in this case from the point of view of Dominic and Davion's families. No doubt that they are angry that their loved ones died in this horrific crash. But seeking vengeance against the sole survivor is not right either. What is required for all parties is healing and counseling services. Part of the healing is recognizing that this was in fact a tragic accident and requires the immediate release of Mackenzie from prison. Sources of information. Sources, page number 1. Sources, page number 2. This concludes this 5-part presentation.